All right, let's get going. So welcome everybody. Welcome. We've got a lot of stuff to talk about today. And Edward, I'm going to rely on you to admit and unmute people as they come in. So first, let's talk about the trial, okay? I was unsuccessful in proving liability on the owner, and therefore, the landlord. So the landlord paid $300,000, and now we have a case for damages against the dog owner. I wanted to talk about the procedure. I wanted to talk about what I learned, what happened. So this was a live jury trial out in Jackson, California, which is an hour from Sacramento towards Lake Tahoe. So the first thing I did when I'm out of town is I look up the demographics of the county. This county is the fifth smallest in California, has 39,000 people. The largest town is 2,700 people, and there's 2 courtrooms in the entire county. Right? So I was going to bring a bunch of people to show them the trial and whatever, but because it was such a small county, I decided to come by myself. The way they did it was a live jury trial, and instead of the jury box, they took the entire courtroom and they labeled like 25 seats about 10 feet apart in the entire courtroom. And we voir dired all 25 people. Now, to add insult to injury, the biggest employer in this county is the state prison. So at least half of them were state prison guards, which are terrible jurors. But fair jury, fair judge. So we started picking from the first 12 when you do peremptories. And normally, if you got one plaintiff and one defendant in California state court, you get 6 peremptories per side. But when you have multiple parties that have similar interests, and in this case, it was one plaintiff versus a dog owner and a landlord who I learned in the trial were aligned, then it goes to 8 per side. So I got 8 peremptories, and the 2 of them had to share 8 peremptories. And then depending on the judge, they go back and forth. And some judges say, okay, you got 8 total, 4 to each defendant, and you can only use your 4. But this judge said any unused of one defendant can be used by the other defendant. And I said, okay, that's fine. All right. Ultimately, we had 12 people at the end of, we used about 3 peremptories. We had 12 people left, and then we accepted the jury. No alternates, no whatever. Right. So the judge was asking early on, if we have less than 12, in a state court, you got to have 9 of 12 to have a verdict. And by the way, in closing arguments, you always have to talk to the jury about 9 of 12. This wasn't a damage case, but in damages, just as an aside, people think they need to be unanimous. And you have to really hit and show the jury instruction that 9 of 12. And I cannot emphasize it enough, because 9 people will give you more money than 12 people. And the way it works is that if they think it's unanimous, they may have 9 votes for $1 million, and then they go around. Does everybody agree on $1 million? Nope. Everybody agree on 900? Nope. Everybody agree on 800? Yes. Okay. And they do that when they feel like we really want to be unanimous. So you got to hammer 9 of 12, 9 of 12, because you may have 9 for $1 million and 12 for 800, and you won't get the $1 million if they don't understand that they can stop after 9 votes. Okay. Anyway, so what happened was the jury instructions, Cassie jury instructions, have a dog bite statute for dog owners, but there are no jury instructions for landlord responsibility of dog bite. And so the judge gave a special instruction. Now, I will tell you that the number one reason that verdicts are reversed is because of special instructions. So most judges, and when you're trying a case, if you can find a pre-printed Casey instruction that applies to your claim, you want it, the judge wants it, because that's the number one reason that verdicts get, because of special instructions. So the judge wound up giving a special instruction that said, the landlord has no duty to inspect the property for dangerous animals. And 2, they're only liable if they knew or must have known. And then the dog owner said, yeah, whenever she came over, I took the dog in my car and I drove off and hid the dog from him. And so that was pretty tough to get over. But I got 100% on the dog owner, but she probably doesn't have that much money. So anyway, no disrespect. The judge was probably right on the law, but it made it difficult. So everything then for me changes. And so the issue is, if you're going to have an instruction like a special instruction that is material, don't you want to have that instruction at the beginning of your case? Because when the judge went over and said, I got to prove that they actually knew or must have known, then that changed my evidence for the whole case, right? And now I have to cross-examine the dog owner and say, you're lying when you said you hid the dog. And then I had to prove a conspiracy. And the defendant landlady was 94, remote access, confused. And I was like, oh, shit. Okay. Anyway, but day and a half, easy trial. It's been in my office for 3.5 years, and we got the first 300 for my client. So any questions? Oh, the last thing, when we started, I talked about COVID being questions, but I found that it was very difficult to ask COVID questions because everybody is COVID concerned, everybody. And it turned out that the COVID questions did not come up by anybody, including the judge. And it didn't seem to be a big deal. So any questions on the trial, special instructions, how the process works? Jeff?
Where did you get the $300,000 from?
We had previously had high-lows that if I could prove liability against the landlord, they would pay $1.3 million. If I couldn't, they would at least pay $300,000.
I see, that's great.
And so, and then I would just go for additional damages against the dog owner based on whatever percentage liability they had.
Thank you.
Yeah. Catherine.
For the special instructions, how do you get that at the very beginning of your case if the judge hasn't ruled on it?
So when you submit your jury instructions, pretrial documents, you have to submit agreed upon jury instructions, contested Casey instructions, and any special instructions. And you have to write what the special instruction is. And at the top, you put the authority, the case law that you're grabbing it from. And you can imagine that these special instructions are crazy, right? They're like, I instruct the jury to vote for the defendant, right? I mean, it's crazy stuff. But when you realize that there may be a special instruction that's going to be given, you at least need to ask the judge before you start picking a jury for some indication of how they're going to rule, because that changes your voir dire, changes your opening, right? So, any other questions? Now, I consider this a loss, although it wasn't a loss, it was. And I say that because I have gotten past the point of worrying about people think I'm a winner or a loser, because I'm a winner, right? But I want to say any trial lawyer that says they've never lost a case is either not a trial lawyer or a liar. But I'm very happy with the experience, because the only way that I could get money for my client that was tied up in that case was to do this process. And I think the jury got it right, actually. I think they were right. So I don't think the old lady knew. So any other questions?
Well, and you said that had been sitting in your office for a while, huh? So at least she was able to get some recovery.
It was sitting for almost 3 years.
Yeah.
Yeah.
Actually, Mike, I have another question.
Yeah.
Regarding the high-low. How do you go about starting that conversation with opposing counsel to have a high-low?
So, and we'll talk a little bit about this later too. You got to think outside the box. So we were going to have to spend X amount of money, and we negotiated this like 3 years ago, right? And we were trying to see how could we get this case tried faster. And I mean, she got serious facial injuries. And by the way, she had a mask on and did not look hurt at all. And so we had to describe the injuries, but they wouldn't let the mask come off. So the jury didn't see any of the injuries. But you just got to raise it with counsel. And this is an example. Remember, I talk about we have these things that we believe in. Oh, I got to send in a meet and confer letter, or I don't know what the insurance policy is. I got to wait 40 days for them to respond to form interrogatories. And we have kind of forgotten that you can pick up the phone or send an email or send a text to opposing counsel. And if they're a pretty good lawyer, they'll short circuit a lot of that stuff. So how did we get a high-low? The defense lawyer is a nice in-house counsel up in Northern California. And I called her. And I said, hey, look, we can prove whatever. There's positives for you, positives for me. Why don't we do a high-low? Because you're adamant that your client didn't know. Prove it. If you can prove it. So 300 was less than the value of her injuries. $1.3 million was more than the value of her injuries. So, all right. Next. Everybody okay so far? Thank y'all. So I hope everybody enjoyed the goal setting process. A lot of people did it, jumped in, and a lot of people have followed up with me and given me feedback. And I wanted to talk about something that if you have your goals, hopefully you have written them out, you put some time on them, and that you have them. And the reason that written goals make it 80% more likely to accomplish is because they become guideposts, right? In whatever way you have them, your binder, up on your mirror, whatever, when you look at them, they spur you to action and they become guideposts that pull us out of our everyday, mundane, week to week, month to month stuff. And the reason we accomplish those goals is because when we look at those written goals, we go, oh yeah, let me go, right? But here's what is required that makes it more effective. And I found this from a number of people that followed up with me, is that they need to be specific enough to cue you to take particular action. In other words, if you say, I want to lose weight, that is so general that it doesn't give you, it makes it less likely for you to form a plan of action. So instead of having a goal of losing weight, say in 3 months or 6 months, I want to lose 10 pounds, right? Now, when you look at that particular specific thing, it's accomplishable. And it's something that you feel like you can take a step toward. I'm going to go work out. I'm going to eat better. I'm going to push this donut away, or whatever it is we all do. And it's much more likely. I want to buy investment property. That's so general. Instead, I want to buy 3 investment properties this year, right? Or in 6 months, I want to buy 1 investment property. Instead of saying, I want to be a millionaire, you say, I want to make X amount in a certain defined period. So for everybody who's done their goals, I would suggest you take another look at your written goals and try to make them a little more specific, right? And remember, there's no mountaintop here. I was talking to somebody, they go, I just want to make sure I do it the right way. And I'm like, there is no right way. And the problem when we all think that there's a right way, we think then there's a wrong way. And if we're not doing it right, then we must be doing it wrong. And if we're doing it wrong, screw it, we're not going to do it. And that is not what this process is about. It is the process of setting goals. They can change. You can cross them off. You can add more. And the final thing I'll say is renew, when you look at them, the idea that everything you want is right outside your comfort zone. So these goals should not be attainable in a week, right? If you can get them done in a week, they're not real goals, right? They're just activities you're going to do next week. So you got to push yourself, but be cognizant that you don't have to make goals that are so crazy unreachable, because then you shut down, right? And there's no right way, and you can change it. But if you want to be president of the United States, maybe that's not a goal you're gonna beat your head in a while, but maybe you want to be in something else. So be specific, outside your comfort zone, but not so crazy that it shuts you down. Okay, so take a look at your goals again. Next, we're doing. So when I opened my practice in 2000, there was no listserv. There were no emails. There was no Google. There was Prodigy, phone line. And when you needed expert information, you had a pre-printed book called O'Brien's Evaluator, and you would look up and they would list all the lawyers who have used a certain expert. And I wrote to those lawyers, plaintiff's lawyers, and said, if you got an old depo, send it to me. And then I opened my practice and I scanned all those depots into a database for me to use, right? And then I started my practice, and for the first 3-4 years, 95% of my cases I had within 1 to 3 months of trial. That's all I did. And so all my depots were expert depots, and then I would try 10 cases a year. And I started putting all these in my database for me to use. About 3 years later, the listserv starts. And people go, anybody got information on Dr. So-and-so? And I would send it to them. Now, fast forward 20 years. We have this database that's got about 7,000 expert depots and transcripts that I want to renew everybody's ability to ask for anything of that for free. And I will send it to any plaintiff's lawyer for free. But then I want to introduce Sheila from Four Corners Deposition Summaries. And Sheila and I were having a conversation, and what they do, I love them, and Robin's here too, is they would summarize depositions from all these different plaintiffs' lawyers all over the area. And a large percent of them would be summarizing expert depots. And so Sheila and Robin have reached out to their clients and said, would you authorize us to donate not only the transcripts, but their summaries to our database? And she's already given us another 100, 120 more depositions. And now in the database is not only the transcript, but a fantastic summary of that transcript. So when we look for cross-examination of how many depots you've done for the defense or ever worked for this, and they all lie, now we can actually have a summary of the transcript. So I just wanted to introduce Sheila, have her talk about what they do, because we use them. And Sheila, if you can explain how the depot summaries that y'all do actually break down by topic, and then I'll say a few words, but go. Welcome. Thank you guys very much.
Thank you for having me on AlderTalk. And if you don't know who I am, I'm the president and owner of Four Corners Deposition Summaries. And we have been around for 11 years. So you can imagine how many depositions we've summarized in, tens of thousands of depositions. And you're right, Mike, the percentage of those are experts. So when we summarize an expert depo, usually it's the same topics. They go through the background, they go through the breakdown of cases, how many cases that their prior cases, and then they get into the opinions, and then they talk about whether they've given all of their opinions, and we capture those as topics. So We include a table of contents at no extra charge. And we summarize expert depositions at no extra charge, even though they're harder and they take longer. Sometimes they take twice as long to do them. We have a flat rate per page and we don't charge extra for experts. So the reason I'm super excited about this project is because this is something we've always wanted to do as well. I've actually known about AlderLaw's expert database for years. And I thought at the time, and this is probably before we started working together, Mike, probably. So I thought, wow, this is a great idea. Those expert depots are just sitting there. Why not put them to use and help people? And so it was a dream to make a database out of our work and what we've done. And I never dreamt that we would merge our database with the AlderLaw database and create even a bigger and better database. And we don't just work with plaintiff lawyers. We work with all types of lawyers. We work with civil rights lawyers, Umberto Guizar. I mean, we work with products liabilities, asbestos lawyers, even construction and real estate and divorce lawyers. So we will be adding to the database all different kinds of experts. So there's going to be a lot of different.
And I wanted to say thank you to Sheila and to Robin. What a great contribution they've made to all of us. And I will tell you that we use their services, and it is for most cases, the cost that to summarize is a recoverable cost as well that you can put into your case. And then what?
Oh, sorry. Yeah, we help the lawyers recover these costs. We have court orders that we send. Our clients have given permission that when they recover the cost of the depositions, we can forward that order over to you. Some of our clients have it as a cost in the case and get it from the clients, or take it from the settlement. So.
And the last thing I was going to say is that when you're in trial, what you need is, I have a 5 mile rule and a 5 second rule. The 5 mile rule, I tell my clients that within 5 miles of the courthouse, you got to think that every person around you is a potential juror. That means don't flip them off. Don't flip people off who cut you off. Don't grab the last parking spot. Don't talk on the phone while you're going through the metal detector. Don't jaywalk. Don't laugh hysterically. Don't cry hysterically, and don't cuss. God damn it, don't cuss, right? The 5 second rule is when you're in trial, if you can't find what you need in examination or cross-examination in 5 seconds or less, usually you're better off moving on, right? How many times you're like, Your Honor, I'd like to read from, right? And the jury's hating. What's great about the summaries is not only do they summarize it, but to the left, they put the topics, and they're able to pull out the topics of that conversation. So you can imagine for witnesses, like on this dog bite case, like, right, when you say, did you ever hear the dog growl? There's a little topic that I can look at, and then the summary of where the testimony is. And it's very, very helpful. So I would strongly encourage it. So thank you very much for being here and doing this.
Can I chime in a bit on something?
Yeah, go.
Yeah, I recall like 10 years ago, I did a trial where I asked for all your depo transcripts. There were like 7 experts that the defense had. You gave me, not kidding, about 40 transcripts. And I had to read all those damn transcripts. And I walked into court with boxes of those transcripts. I had like 3 boxes of transcripts to impeach the defense experts. And it was against Doherty, which Doherty, he had beat everybody.
Yes, they
He
hate.
was like so arrogant, and he was asking if I had these depo transcripts from the Cala people, and I said, who cares, right? But to make a long story short, this depo summary stuff was a long time coming because it would have helped me a lot, because I spent numerous hours reading through those depots, and I impeached the witnesses and I won, but would have saved me a lot of time if I had those depo summaries that Ms. LaCivita prepares.
Yeah.
So thank you for merging all that stuff together. It's really great.
We're happy to be a part of this.
If you all have expert depots, trial transcripts of crosses. If you've done research on experts and you've got their CVs or their reports, please send them to us. You can, in any of the social media on our link tree, there's a way to connect it. Everybody knows Rita at my office. Rita is the person. Just please send us. Reports are really important, right? When you have 40 reports from an expert and the summary paragraph is identical in all 40, it's very powerful stuff, right? So reports, trial transcripts, their website, and of course their depo transcript. So please contribute, and then anything y'all want from me is free. Speaking of free, nobody's taking me up on the Warrior Fund. So the Warrior Fund, again, is I used to do it for trial, but now we've expanded it to for younger lawyers, less experienced lawyers. I will help you fund your case for free. If you lose, I'll eat it. If you win, give me my money back. It's called the AlderLaw Warrior Fund. And everybody goes, I don't want to use it because there's a catch. And I'm like, there ain't no damn catch, but everything's got a catch. And I'm like, there's no catch, right? And there's no catch. So please, if you know younger lawyers, new lawyers, whatever, I want to make that available. I've earmarked the money for it. It's just sitting there. Okay. Last couple of things before we open it up was the YMCA bag event we here at Casa Alamar. So many of y'all contributed so much. You know, I'm on the board of the big Metro Y, but we do a lot of volunteering at the East LA downtown YMCA. I go there once a week. And last time we asked, what do they need? And they service so many food insecure people and homeless and or people that are semi-homeless. And they said, we need toiletries. We need toothbrushes, razors, shampoo, hairbrushes, bottled water, diapers, a lot of diapers, stuff like that. And so we decided to do a bag event here in Sherman Oaks because a lot of people on the west side don't want to drive down to downtown and so we did it here. So many of y'all contributed. We put together 250 bags of a whole bunch of different personal hygiene stuff. And that will last East LA 5 weeks to be able to help people. So I wanted to say thank you all very much. We're going to do it again at some point, but it was very successful, and people, you don't even know. A mom who needs diapers and she doesn't know where to get diapers. You don't even know what it's like to give that person a bag of that stuff. It's amazing. And a bunch of people brought their kids. They saw the goats and the chickens, but the kids also participated. And it's just an amazing experience to show your kids what it's like to give back. And everybody was all in. So thank y'all very much. So I'm going to stop, see if anybody wants to talk. I got some other topics, and some other things to talk about, but we're going really fast. But does anybody have anything they want to talk about? Stuff, where we've kind of hit a bunch of things this year. COVID, how's the practices going? Things are everybody's getting vaccinated at some point? Anybody? Go, David. Go, unmute.
Self here. Yeah, I got vaccinated at CSUN.
Yeah.
For those of us 65. But it's great. It was a simple process. You're in and out. The first trip was maybe 15 minutes. Then you wait 15 minutes afterwards. They observe you in the car. Second trip, I think I was there 30 seconds before I got the needle in my arm, and it was just terrific.
And I had this trial call. I have the case I was on this morning is a preference, and my trial was March 3rd or 2nd. But the Ventura County judge said, look, our numbers are not going to allow us to do a live trial. So we kicked it to mid-April, even though it's a preference case, in hopes that by mid-April, we will have enough jurors to come and do a live trial. But still, especially down here, the numbers are pretty tough. Yeah. Still, that is scaring judges, but it's getting better, huh? Anything else? All right. How many of y'all have started to use Esquire Tech for discovery? Anybody? I got to tell you, it's a game changer for our office. I see emails coming up all the time about a client has now opened the Discovery Esquire Tech. I was taught, so what it is for you all who weren't on it 2 weeks ago, Pratik Shah, who's a PI lawyer in San Diego, has created a program called Esquire Tech, ESQUIRE TEK. And it's a discovery tool where you can take discovery, download it, it will scan it, put the question, and then put a blank, and then you can email or text your client the entire package, and they'll read the question, fill in the answers either by text or on email. There's preset objections that you can check or customize your objections. You check those, hit a button, and it will generate your entire discovery pleading for you. It will also let you know when your client has opened the email or the text and how many of the questions they've answered and how many they haven't answered already. So great. And Pratik said next month, instead of, they're going to offer the per discovery request like $15 still, but they're going to do a monthly, you can do it as much as you want in a month, a monthly fee. And he said if you use it for most of your clients, the monthly fee will be more economical. And so we've already seen time and cost savings. And it's just great because you know when your clients are entering discovery, right? You don't have to call them. You just know when they answer it. And most of our clients respond to the text more than the email. And they can dictate the answers in their phone. It's very, very convenient and great. Hey, Evelyn.
Hi, Mike. How are you?
Good. So has anybody else had any good or bad experiences with Esquire Tech? I don't get a commission, I promise. Not yet.
Is it propounding discovery yet?
It's not propounding, but I don't know why you, I wouldn't know how you use it to propound discovery, like
Okay.
The form rod. So remember how we talked about a long, long time ago, what can you do to move all your cases forward? And one of the things is answer form rogs, even pre-lit, and send it to the other side, because the reason they're form interrogatories because they're so helpful to both sides. So what we did is every case we have, lit or pre-lit, where we have not answered form interrogatories, we send it to our client, every single one. And as soon as we get the answers in a final form, whether the defendant has asked for them, whether we have filed suit yet, we send it to the other side. And I got to tell you, when a defense lawyer calls you and goes, hey, I just got this discovery I didn't ask for. I'm like, yeah. They're like, you're not allowed to do that. I'm like, sure I am. Do you need it? He goes, yeah, I meant to do it. I'm like, exactly. Now we're 2 months ahead. But they also are like, man, secretly, they're like, all right, that firm's a badass. We got to settle this case. And so remember, insurance companies put you in categories. And I see, I talk to some of the lawyers, younger lawyers in my office. People are like, well, you know what? My client's treating, I know I got 2 years on the statute, so I can file a month before the statute. And I said, don't do that. They go, why? It's still filed. I said, but look, leopards don't change their spots most of the time. And we're all leopards and we all have our spots. And insurance companies has figured out that a leopard that has the spot that says, I will file a month before the statute, the other spots on that leopard is, I won't try a case, I will take lowball offers, I won't hire experts, and if you wait me out, I'll fold. Oh, that's not me. Well, leopards don't change their spots. When you get a lowball offer from a pre-lit adjuster and you sit on it for a year, that spot is the same leopard that has, I will not hire experts, I won't go to trial, whatever, right? Conversely, the leopard that has the spot that I will send you farm rods immediately, whether you ask for it or not, the other spots on that leopard is, I try cases, you can't lowball me, I will pay money to experts, and that's how you get money. So not only are you sending the information they need, you are telling them that you are the person, the leopard, that won't take lowball offers, right? It's why many of the times I meet people and I interview people, I ask them, do they make their bed every day? You're like, what the hell? You'll never see my bed. I'm like, no, I won't. Nor will anybody else. But that's not the point. Do you make your bed or not? Because the person that makes their bed when nobody sees it is the same leopard who has other spots that are motivated, that move forward, that do stuff, whatever. The insurance companies use it on us, and I use it on people. There's only about 9 different types of people in the world, right? 9 different leopards that generally fall down, which is why when somebody writes me a note, when somebody follows up, when somebody brings donuts to the interview for the staff, hell, we could afford donuts. But the type of person that thinks ahead, that brings those donuts to the staff, is the same type of person that's going to stay up all weekend and file that summary judgment opposition, who's going to try cases and who's going to be interested and read my stuff, right? So anyway, I forgot to mention that with Expert Depos, I just bought, again, I bought it like 4 times and I've lost it every time I've moved, a great 2-volume book on taking expert doctor depos. So some of y'all have seen Dorothy Clay Sims, and it's a book called Exposing Deceptive Defense Doctors. Dorothy has given speeches. She's a lawyer, plaintiff's lawyer around the country. She's been in all sorts of stuff. I think she's been on some of the TBI webinars, but I know it's a hefty read, but just the table of contents are some of the most amazing ideas on how to get cross-examination. First, diagnosing the doctor, what to do before and after a defense medical exam, cross-examine at trial, debunking psychological tests, junk defenses to psychiatric and neuropsychiatric conditions, debunking exaggerating and malingering claims, cross-examination and depression, PTSD, CRIPS, ERISA claims, just wonderful stuff. Just wonderful stuff. Now, it does take a little bit, but you don't have to, it's not a book that you have to read from cover to cover. Depending on the type of case you have, you can go directly, and the ideas are phenomenal. And what I'm going to do is when I see some good ideas, I'm sorry y'all are getting so many damn emails, but Rita, I'll send it to Rita, and then she'll send it to you guys and say, oh, here's a really good thing when you do your cross-examination. If you don't like it, delete. If you do like it, then you'll take some good cross-examining of experts. Last thing, and then we'll talk for the last thing. I am a member of LawWorks. Reza and Poonam Torchade together had created a LawWorks. A lot of people think it's like Justice HQ. It's a little different, but it is kind of a WeWorks for lawyers. And both of my AlderLaw and Zapont AlderLaw are members, and it's a wonderful in COVID, a wonderful way of extending your office. It's not very expensive. I think it's like $250 a month, but it's such a wonderful setup, and they have a great setup in Orange County, and they're expanding. But I wanted to say that because they're doing talk series. It's open to anybody who wants to watch, and on March 3rd at 10 a.m., I'm actually going down there, and I'm going to use their new electronic board, and I'm going to do a deposition, taking killer depositions And it's basically the class that I teach at Loyola. And I'm going to show the new board, talk about techniques to get people to answer your question. And then I'm going to show on the board the video of past depots as I'm using those techniques, and you'll see how people fold. So everybody's welcome. I'll have Rita send it out. But there are techniques that I have developed over the years in depositions that I've talked a little bit about here that you will get people to answer your question. And if they don't, you will get great cross-examination. And I'm going to not only tell you about it, I'm going to show you by me doing it live in other depositions and how we get it. So that's March 2nd at 10 a.m. It'll be Zoom and remote, and everybody is welcome. You don't have to be a LawWorks member to do it, but I am, and I know them, and I work with them, and I love them. And Reza was on the show. So, all right. Anything else? Y'all feeling better about COVID? Come on. We're getting there, guys. We're getting there. What did Biden say? By Christmas time, it'll be normal again. I'm just looking forward to SEC football starting in September. Going to Europe in October. Come on. Anything else, guys? All right. Yeah, David.
Don't forget, LSU Tigers come out to the Rose Bowl September 4th, play UCLA in football.
If you're a UCLA fan, I'm sorry for you. But anyway, thank y'all very much. This is for anybody who wants to see these later. We have a YouTube channel called AlderTalk, and you guys, all this stuff in all the past, you can go back. If you wanted that, Esquire Tech explanation, you can find it 2 weeks ago, and feel free. AJ.
Sorry. So for depo summaries, probably like text or email read on a weekly basis. How do we contact Sheila?
Oh, Sheila, can you access the chat, or Robin?
Oh, yes. So you can email us, call me. You can even call me on my cell phone. It's as public as my business.
So I see on here that Sheila put in the chat her email, Robin's email, and the 888 number.
Yeah, that's our business line. Yeah.
Any other information you want to give?
Yeah. I mean, you can call me directly on my cell phone too.
All right. I'm going to put that in there. Sheila's cell is what?
818-269-9896.
9896.
So yeah, I answer every call.
Okay. Excellent.
Anytime you need anything, any depo summaries, we'll look it up in the database and see if we have it. And we can also help you with any future depo summaries as well.
Thank
All
you.
right, guys.
Mike, I have a question.
Yeah.
On the expert depositions, are you going to create a separate database for, use of force experts, things like that in the civil rights? Because I don't think you had that before.
We're working on that.
I have tons of depots I can send you.
Do it.
Oh, awesome.
And I think Sheila has summarized many of them as well. So
We just finished a couple for you, and I think Robin's on it. I think Robin has another.
So 2 years ago, we gave out 3,200 separate requests for depositions. It's a great resource. I say, if you don't call Rita and ask for this, you commit malpractice, because we got so much stuff. It's great. It's great. So guys, thank y'all very much. Life is beautiful. Perspective is everything, right? 3 things we're grateful for. Think about it as we log off. You can always find the sun behind the clouds. So even if it feels like it's not going great right now, this too shall pass. And I really appreciate everybody contributing to our community. So love y'all, and I'll see you in a couple of weeks.
Thanks, brother.
Thank you, Mike.
Thank you.
Thanks, Mike.
Bye.
Bye.
Bye.